There are five sources of obligations. The first one is the law. Not because of the violation of the law, but because the law provides for its obligation. Let's say, for example, uh, your duty to pay taxes. That is provided by the law. The only thing that you need to consider under this provision is that the obligation must be expressly determined or expressly provided by the law. So if it is not in any way provided by the law, there is no obligation to do it. Let's say, for example, nowhere in the law is the lawyer mandated to provide a lawyer for his or her employees. So if it's not provided under the law, then the employer is not mandated or obligated to provide lawyer for his or her employees. The second source of obligation is contracts. When we say contracts, contracts is the agreement between two parties, two consenting parties. So there must be a meeting of the minds. And the civil code provides that contracts have a force of law between the parties. So when we say it has a force of law, then both parties have the obligations towards each other. One thing that you should also consider with regards to contracts as a source of obligation is that there must be compliance in good faith. So since both parties entered voluntarily into an agreement, then both parties must comply in good faith. And the indication of this is that not one party may unilaterally uh, revoke or terminate a contract. It must be agreed by both parties. So one party cannot just revoke or escape his or her obligation. An example for this is, let's say for example, you entered into a contract of loan, therefore you have the duty to repay the loan. The third source of obligation is what we call quasi-contract. Quasi-contract is a juridical relation. It is a juridical relation between parties because of a lawful voluntary act. In other words, ito popular sa mga law students and uh, legal management students. No? We have what we call the principle of unjust enrichment. No? That no one should be unjustly enriched at the expense of another person. That is quasi-contract. One example of this is negosyorum gesture. Negosyorum gesture is when one person takes over or manages the business or property of another person without any contract. That person who manages or who preserve the property is entitled for reimbursement. No? In that case, there is an obligation created. Another example of this is solution indebity. So you know what solution indebity is, yung unjust enrichment, okay, or undue payment. No? Let's say, for example, you have mistakenly paid someone an amount of 10,000 pesos, mistaking that person for your creditor. Akala mo siya yung creditor mo, hindi pala. Siya ang nabayaran mo. That is undue payment. It creates an obligation on the part of the person who received the undue payment to return the money paid, no? Plus interest if there are under any circumstances. So the fourth source of obligation is what we call as delict. No? Delict or things alam natin as crimes or offenses. No? Under criminal law, it is a basic principle that for every criminal offense, there shall be civil obligations. No? So lahat ng crimes, mayroong civil obligations. Doon pumapasok yung obligation arising from crimes. No? Yung civil obligation mo. Kasi lahat ng crime mayroong civil obligation. And the fifth one is what we call quasi-delict. Yung kanina is delict, ngayon naman is quasi-delict. Quasi-delict is anchored on negligence. Ito yung tinatawag nating culpa aquiliana. Culpa aquiliana. Yan is civil obligations arise because of the negligence of another person. No? Pwede ka mag-claim ng damages because of that. So those are the five sources of obligation. We call law, contract, quasi-contract, delict, and quasi-delict. Thank you.